Well, first of all, it's great to see everybody. I walk around the room, so many familiar faces, and it's so wonderful to be out after COVID, right? To be able to see everybody in person, shake hands, look people in the eye, and get together and talk about important stuff. I'm going to tell you just a little bit about what it is to be the chief judge. There is this thing called the Safety Act, and I'm sure that there's lots of questions about that, so I want to reserve the most time for that after Eric Weis gets up as well. What does the chief judge do? Well, first of all, to give you a little bit of background on how I became chief judge, born and raised in St. Charles, I've been in Kane County my entire life. My mom was a teacher at St. Charles East and out of Canelan. My dad was a salesman for St. Charles Kitchens. I've been married for 30 years. My wife grew up in the city. I convinced her to come to St. Charles, and we have been here ever since. Raised 4 kids. My youngest is a freshman at U of I. I have a junior at U of I, one that graduated from U of I. You get a theme here, ILL. There we go. And then one who's a 26-year-old working for the St. Charles Park District. As Debbie said, started my career as a prosecutor at the Kane County State's Attorney's Office. That's where Eric and I met. He was a prosecutor in Kendall, and absolutely loved that job. In 2009, when I was trying to figure out how I was going to continue to support my family, I had an opportunity to become a judge, and I took that. And I've been a judge since 2009. I ran to be a circuit judge in 2018 in what's called the 4th Sub-Circuit, which is Geneva, Batavia, St. Charles, and won that election uncontested. And then just a couple years ago, ran and was elected chief judge of our circuit. So 16th Judicial Circuit, which is Kane County, we have 31 judges, 14 elected, 17 that are appointed. We have 6 different courthouse locations throughout the county. We have a courthouse location in Elgin and Aurora, which are our branch courts. Kane County, which I refer to as the old Montgomery Ward's building, where my mom bought my pants as a kid. We have the Judicial Center, which is right out on 38, our beautiful 3rd Street Courthouse, which I just always love at this time of the year. And then we have the Juvenile Justice Center, which a lot of people don't know about, but it's right over on that Judicial Center campus. As part of the chief judge, people say, well, what does the chief judge do? Well, one of the jobs, and the main job I have is administratively, I oversee those judges. We have to put judges, we have to look at judges' talents and strengths. We have to look at the court calls that we have to serve. And I think my most important job, I love sports. I've loved sports my entire life. I think I see Chris Anderson out there, a pickleball player, right? I've loved sports my entire life. And so it's trying to align the strengths that we have with the courtrooms that we need them at so that we can provide, and I really look at, there's 4 things that we need to do in the court system. 1, we need to be able to move courtroom cases efficiently through our system. Justice delayed is justice denied. So we have to do that in a timely manner. Second, we have to deliver that service effectively. And so when we're talking about that, we want to make sure that we take advantage of the resources that we have. We want to make sure we're good stewards of taxpayer dollars because ultimately as judges, we work for you. Our salaries are paid by you and we have a responsibility to you. And then third, and I think when we're talking about the Safety Act, which is really important, is transparency. Again, when we get to what we do, we need to be able, you need as taxpayers to be able to see what we do in the court system, and we need to be able to share that information with you, which when we talk about the Safety Act, that transparency piece wasn't necessarily there. Again, then what we do here in Kane County as chief judge is, in addition to the judicial responsibilities, the chief judge's office oversees court services, which is over 100 employees with about a $9 million budget, a lot of which is paid for by the state. We oversee the Public Defender's Office, the Kane County Diagnostic Center, the Juvenile Justice Center. And so at the end of the day, there's just a lot of moving parts to run our court system. And those are a lot of things that people don't necessarily understand are part of the Chief Judge's Office. Before I turn it over to Eric, things that I'm very proud of that I want to share with you. Number one, when we went through and we went through that COVID situation and we had to try to adapt, there were a lot of circuits that just kind of put their head down and decided that they were going to close their courtrooms and really not work on trying to figure out how do we solve this problem. I'm looking at Chris Lawson, who was our chairman at the time. We worked together, the whole county really worked together to figure out how was it that we were going to do this. And what we ended up doing was innovating and using technology to be able to continue our court system. So we don't have the backlog that a lot of circuits have because we were able to innovate and adapt. Right now, a lot of our focus is on the Safety Act, and again, I want to leave time for questions for that. That's Eric and I have been, Eric, when did you graduate from law school? 97, so I graduated in 93. In our lifetime, and we've both been in the criminal law field for a long time, we've never seen anything like this. It's transformational. And so for our system, we've had to work very hard over the last year to prepare for that. And we're ready. We're ready. Whether we like the legislation or don't like the legislation, as a judge, we have to be ready to go, and we are. And then what we've tried to use some of the savings from COVID to do things that we needed to do. Two things I'm really proud of. One is we have had a spike in abuse neglect cases in Kane County. Those abuse neglect cases are kids who have either been physically, sexually abused or neglected, and the court system has to get involved. Unfortunately, those cases have risen by about 200% in Kane County over the last couple years. What we were able to do, though, is we used to have one courtroom that served that population over here at 3rd Street. We had another courtroom that served that population over at our Juvenile Justice Center. And a lot of times those families were intermixed and they would have to go to 2 different locations. So we were able to work with the county board, use some of those savings, build out a second courtroom at the Juvenile Justice Center. So now when those families are being served, we have 2 courtrooms in the same location with the 2 judges being able to help themselves. And that helps resolve cases faster, and more importantly, it's great for the families. Second courtroom that we're building out right now is a new courtroom that's going to focus on orders of protection. I was talking to one of our gentlemen over here who's a court watcher. Again, what do we want to do in the court system? Part of our responsibility is to protect those that need to be protected and to help them. Victims of domestic violence right now, they have to share a courtroom with another courtroom. It's a very busy courtroom. What we're going to do is build a courtroom out where we can focus and give them the attention that they deserve on that. And that's going to be done on January 1st. So some really, really great things going on. I could talk to you for a long time about it. Happy to answer questions after we get done. But again, to Debbie and to the organization, I just want to say thank you for giving us an opportunity to talk about the Chief Judge's Office. So I thought Eric was going to talk, so let me just talk to you a little bit about what we've done to prepare for the Safety Act. So again, if you have paid attention, it's impossible not to. The legislation that's going into effect on January 1st is called the Safety Act. There's a 700-page bill, lots that is in that bill or in the law, but specifically is how does it affect the criminal justice system? Well, what it's done is it's ending cash bail. So if I'm making this a little bit too basic, I apologize, but for those of you that might not have known how it worked before, I think it's important to understand that prior to January 1st, if someone was to get arrested, they would appear in front of the judge, and that judge would set a bail. And that bail amount would be based upon the severity of the offense, the offender's criminal history, their ties to the community, and it would be the judge that would utilize their experience to determine what that bail amount should be. Now, what is going to happen starting January 1st is that they are eliminating cash bail. So right now, if somebody gets arrested, they don't have a criminal history, it's a nonviolent offense, a judge might not require any cash bail, or if they did, they'd say you'd have to post $100 to be released. If it was a murder case, somebody that would have to post, or the bail might be at $1 million, which would mean to be released, they would have to post $100,000. What's happening on January 1st is they are eliminating all cash bail, and it's what's called an in or out system, which is either you are detained and there's no amount of money that you can post to be released, or you are not detained and you are out until your case gets resolved. That's it in a nutshell, but what we had to do as a system is prepare for that. And so what we did, first of all, is Kane County was named one of 3 pilot sites in the state of Illinois. What that meant is we've had assistance through the state and through different organizations to come in to help us prepare for this, which has been invaluable. One of the great things about Kane County is how we all work together. So the Kane County State's Attorney's Office, Public Defender's Office, Court Services, Sheriff's Department, social service agencies. We've all been meeting for the last year to try to talk about what the impact of this legislation was going to be and to be prepared on January 1st for it. Now, what I will tell you is we go through that preparation level. One of the questions I get asked, that I got asked a ton at Thanksgiving, that I get asked every time I'm talking to my friends is, what do you think about the Safety Act? Do you like the Safety Act? Are you in support of the Safety Act? And the answer that I give them and that I'll have to give to you is one that isn't always satisfying. And that's that as a judge, my job, whether I like the law or don't like the law, is to enforce it and to be able to rule in a way that's unbiased and to try to make decisions based upon the law that's presented. So as it relates to the Safety Act, whether I like it or don't like it, doesn't matter. My job as chief judge is to get our circuit prepared for that. As I look in the room, one of the things that I've said, and I think when I look at all of us here, I think that you'll agree, is when I grew up in the 1970s, and I went and I said to my mom and dad, I don't want to do this. I don't like this. But the answer that I would get is, too bad, do it. And so the reason I use that analogy is because in the end, whether I like the Safety Act or don't like the Safety Act, our job is to be ready to go ahead and to be ready to go on January 1st, which we are, with hopes that our legislators, with hopes that as we go through this, amendments or adaptions will be made so that we can make it better. Because there are some things, and I'll just touch on a couple things that we are frustrated with as a judicial system. One is that this legislation has taken away a lot of judicial discretion. What the law has said is, judges, you don't get to decide whether to detain this individual based upon the criminal history, based upon the other information that you have. If it's this type of offense, you may be able to detain, but if it's this type of offense, no matter what the criminal history is, you don't have that. And so it's taking away judicial discretion, which is such an important part of our checks and balances and our three forms of government. So the discretion and taking away the discretion is something that I hope will be changed. As we relate to what does it mean, for instance, to our jail population, and then I'm going to turn it over to Eric. Right now at the Kane County Jail, we have about 313 individuals that are being held on various crimes. When we've had Dr. Olson from Loyola has come and looked at our jail population to say what kind of impact will it have, we expect that population will probably drop from about 313 to about 200, meaning that there's about 113 people that are in there that, based upon the types of offenses they're in there on, they won't be released on January 1st, but if they were to commit that type of crime again, they're crimes that we could not detain on. So again, as we go through this and we prepare for it, we as a system are ready to go. We understand that there's going to be bumps in the road. We're ready to address those. And then as we move on, we're going to learn, and I hope our legislators will learn, and I hope that we'll see some amendments. As a matter of fact, I think today what I learned is that there was a trailer bill that was finally introduced. I heard that it did pass the Senate. Now it goes to the next, it goes over to the House, where we'll see if there's any success there. But I will tell you that in reading through the trailer bill, there were some of the things that I just talked about that they've addressed, which I'm very, very excited about. It's by no means perfect, but there are improvements that are being made. So I'm going to turn it over to Debbie again, and then I'll come back to answer any questions that you have. Thank you.
Thank you, Judge Clint. So we have one glimmer of hope that happened in the election. Chris Lawson became our treasurer. So I'd like to recognize Chris for winning. It was nice. It was nice to say, woohoo, we got to win. So anyway, to go back to our night, we have State's Attorney Eric Weis. He's from Kendall County. I had to reach over to another county to try and get someone that I thought might align with what we think. He has been a prosecutor in the State's Attorney Office since 1987. In 2006, he was elected State's Attorney and is serving his 5th term and he is on the Board of Governors for the Illinois State's Attorney's Appellate Prosecutor's Office. as well as the executive board for Fight Crime, Invest in Kids of Illinois. So please welcome State's Attorney Eric Weis.
How many of you live in Kendall? Perfect, I don't have to be nice to any one of you. It is actually very nice to get a chance to speak to you. So, why is Kendall County in Kane County? Well, we're one of the 60 plus state's attorneys that are suing the governor of the state of Illinois and the Attorney General's office over the Safety Act. To be honest, I wish there was no applause, because that should never actually have to happen. This is not a Republican or Democrat process. The actual two first lawsuits that were filed by both Democrat state's attorneys. I work with them, and I'll explain that in just a minute. But I do want to say something, and he doesn't know I'm going to say this, but since we've been colleagues and friends for many, many years, and since I don't work in his circuit and I don't have to appear in front of him, I can say whatever I want. That's the good part about going last. You are very, very, very fortunate to have Clint Hall as your chief judge. I have had the pleasure of working with him. I've had the pleasure of trying one of the most difficult cases in the history of Kendall County in front of him when Kendall was part of the 16th Circuit. One of the most taxing, complex cases I've ever dealt with was in front of this judge. So I know firsthand what it's like to be a prosecutor. I know what it's like to be in front of good judges and judges that may need a little more assistance. I know what you have, and you are very, very fortunate to have Clint as your chief judge. So that being said, I don't have to have all the same rules that he does to answer questions and to give my opinion. But I also am an elected official. I do serve, I don't serve based on my political views. I am Republican. I've been elected five times. This is my fifth term. I am a career prosecutor. This is all I've ever done. I love what I do for a living. I go back and to talk about my office. My office is much different than Kane County. We're a little bit smaller. Our population is 125,000 people. So basically, Aurora is our county size, within a few thousand people. And we've watched Kendall County grow in a way that we are one of the fastest growing counties. We are the fastest growing county in the state of Illinois, but we've been at one point one of the fastest growing counties in the United States. So we've had a lot of the trials and tribulations that bigger counties have, even though we've been smaller in nature. So what can I tell you about the Safety Act? You don't really want to know what I do. I put bad people in jail. That's my job. If you have any questions, ask me afterwards. I'll be happy to explain it to you. What is the Safety Act? The Safety Act is a 700, as Clint said, is a 700-page bill, roughly, that was passed or was presented about 3 o'clock in the morning on the last day of the lame duck session prior to the new General Assembly being sworn in. Now, I don't know how legislation is always supposed to work. I'll defer to Chris Lawson. He was in the General Assembly. He can tell you. But I'm not sure that's the best way to pass bills and to pass laws. There are some good things in the Safety Act. I'm not here to tell you that it's all a bad bill. There's some good things that were put into that bill. The way it was passed, how it was passed, it's part of our lawsuit, so I won't say too many things about that. But there are some good things. There are some good things that help the criminal justice system. There are some good things that help law enforcement. There are good things that protect people's constitutional rights. Those are good things, and anyone who works in the system, whether you're a judge, whether you're a public defender, whether you're a state's attorney, you want those things. I will tell you one of my biggest fears before I get into the Safety Act and the pretrial release portion. My biggest fear is that I would convict the wrong person. Because if I convict the wrong person, the right person is out. Nobody wants to do that. Nobody wants to get it wrong. especially me, okay? And in doing so, we strive for justice. Prosecutors actually are bound by rules of professional conduct, just like all lawyers are. Judges, lawyers, we all have these rules. Prosecutors are the only lawyer that have one additional rule or responsibility or law that we have to follow. And that is to seek justice, not merely to convict. So our prosecutors have one additional, no offense to defense attorneys, private attorneys, defenders, they don't have to follow those. We do. So we take that job very seriously. So it wasn't with political endeavor. I'm not for election this term. I've been elected 5 times. If I don't get elected my 6th time, I'll go do something else. So I don't file a lawsuit against the governor and the attorney general lightly. So why did we do that? Well, there are several reasons. Number one, this law was passed back again about 2 years ago. We're coming up on the 2-year mark now, and it was implemented in different phases. A lot of it dealt with law enforcement at the very beginning, and now we're getting to this pretrial reform act, or whatever acronym you want to use today, to discuss this. I've heard it from the pretrial reform to the purge bill. You pick which one you want. We're talking about the same thing. So what's going to happen? As Clint said a moment ago, I'm not going to repeat all this, but some of it's kind of it's important to understand. Do I always agree with a judge's decision? Of course not. I'm an adversary, right? Take the position of what's going on right now, football. Well, I always like baseball. My kids are baseball players. Sorry, I've got 2 kids. They're both catchers. I live baseball. That's what we're going to talk about. Plus, I have the microphone, so I get to talk, right? As a baseball player, you get to decide, if you're batting in the bottom of the ninth with the bases loaded, you're either going to be the hero or the goat, right? You get to do those things. You get to advocate. You get to do those positions. The judge is like the umpire. He doesn't decide whether or not you should bat that person in the lineup or put that person in the field. They make a call. Ball strike, out or safe. When we come to the judicial system, we have that same discretion. Do I always agree? Of course not, but we have discretion. Judges are able to look at a case, look at an individual, look at a fact pattern, and decide what is the appropriate sentence, what is the appropriate bond, what is the appropriate thing to do in that particular case. What the General Assembly has done, in my opinion, this is just my opinion, is taken that discretion away from judges. They have made it to a point where they have taken what can be a good idea and turned it into a nightmare. They've turned it into a nightmare in several different ways. Number one is they've eliminated the ability to hold people based simply on what the offense is. So, as Clint mentioned a moment ago, there is a process right now going on literally right this minute about trying to fix part of this problem in the General Assembly. But I'm going to talk to you about what the bill is, what the law is today. So if it changes next week, don't blame me. I'm not the General Assembly doing this last minute. They're the one doing it. Right now, certain offenses cannot be held under any circumstances. Arson, burglary, aggravated fleeing and eluding, aggravated DUI death, which means a fatal crash, DUI, 1 or more people. I could go on the list. Those offenses cannot be held under any circumstances unless I can prove willful flight. Basically, you've got a passport in your hand and you're ready to go out the door. That's not what the law is today. The law is today, the judge can consider all the factors. Does the person have, what's the nature of the offense? Probably one of the most serious reasons a judge would hold or not hold someone is the seriousness of the offense. We're not putting people who steal a candy bar in jail for 90 days to 100 days who can't post bond. I don't want to speak for the Kane County Jail, but I can tell you the Kendall County Jail, we are not holding currently anybody in jail for a retail theft. Period. There's provisions already in place long before the Safety Act was passed that already have that provision. We were not holding nonviolent offenders. And we don't want to waste our time. Any good prosecutor will tell you, I get to say this because I'm on the one side. We don't want to hold nonviolent offenders. We got other things to do. We have other cases to focus on. We look at the nature of the offense. We look at their criminal history. How many times have they failed to appear? Right? You know, talk is cheap, actions speak louder than words, right? I look at someone, if you fail to appear 5 times in court, what's the likelihood you'll appear the 6th time? Well, they've taken that away from us too. It's not simply did you fail to appear, it's, well, why did they fail to appear? I don't know. And it burdens on me to show why they failed to appear. So, Clint, why did you not show up to court 3 years ago on the 17th of January? Eric, prove why. I don't know. I wasn't in his head. I wasn't in his house. Do people sometimes not show up to court because of circumstance outside their control? Of course they do. Someone gets sick, they have a flat tire, something happens. We all are that. We're human. That happens. But they've taken that out of our discretion, taken out of the judge's discretion. Because you know, at the end of the day, who's going to get blamed for all this when they get released? Not me. And I'm going to stand up there, I'm going to go to work on January 1st. The judges are going to get blamed. Judge Clint Hall released a insert name here offender on without having to hold him, and they went out and did some dastardly deed. And all of you are going to look at Judge Hall and say, Judge Hall, you shouldn't have done that. And it's not his fault. His hands will be tied. Okay? From our end, my job is to protect Kendall County. Right? My job is to protect the victims of the crimes that are committed. Does it give us the ability to hold certain offenses? Yeah, it does. Like I said, there's some good things. But it makes the process so difficult. As it currently stands today, I'm going to give you the example that nobody likes to hear. I've been told that I'm wrong, and I'm like, well, point me to the statute because I can read it. I'm somewhat educated. I had to go to Oswego High School, so I'm not the brightest bulb in the tree. But I can tell you I can read. So here's your case. It's a pretty serious one, and please don't take offense if this applies in anyone's circumstance. If this has happened to your family, I'm using it solely for the purpose of demonstration only. So I don't like my sister. I have a sister. She's the only person in this world that I don't like. I love everyone else in the whole world except her. So I kill her in cold blood, confess, videotape it, whatever you want to put. You pick whatever set of circumstances to prove my case. I come before the court. 1st degree murder, no question. Am I going to be released? What do you think? Am I going to get out of jail? Raise your hand. Do you think I'm going to get out of jail today? Do you think I'm going to get out of jail? Probably not. Right? A couple of you. I guess there may be a Cook County judge or two that let you out of jail. Or maybe they won't prosecute you in Cook County. I don't know. But assuming you're prosecuted, assuming you're from a reasonable-minded judge, right, which most of them are, you're going to be held. January 1, there's a very good possibility you're not going to be held. Why? Because we as prosecutors have to show that you are a risk of harm to a specific identifiable individual, not just the community, a specific identifiable individual. DUI, right? Bad ones, right? The ones we can't hold anyway. But even if we could, who are they a threat to? Which specific one in this room is the threat if I get behind the wheel of a car and I'm drinking and driving and I crash? Which one? Because I got to name it and I got to prove it. Does that make any sense to anyone? Probably not. But that's the way the law is written. Now, there's some trailer bills that are trying to fix that. Say, well, we'll go back to the community. Let me give you one other example. People that don't show up to court, right? Does everybody know what happens today if you don't show up to court?
Bench warrant.
So, warrant. Somebody said bench warrant. Yep. Most of the time. You know, once in a while, the judge will give a short date. You know what? Defense attorney, hey, my guy called, give him a week, great, whatever. Sure, come in next week. If you show up next week, we'll deal with you next week. It's not like you don't have anything else to do, right? We will not have the ability to issue warrants automatically. we will have to have our sheriff's office go to wherever this person may or may not be and serve him or her with a piece of paper that says, we know you didn't come to court the first time, you need to come to court now. How many sheriff's deputies do you think it's going to take to serve those papers? Well, a lot more than you have today. And again, they've realized this is a problem. This is not something that's gone unnoticed. Because I don't know what I tell a victim. Hey, your case is on hold indefinitely until we can find this person and serve them with a piece of paper. Now, whether you want to get rid of cash bail or not, I don't have a strong opinion. I can see the arguments either way. You know what? Someone who has money should not be able to get out of jail simply because they have money. And someone who doesn't have money should not be able to have to stay in jail simply because they don't have the money to post. That should not be the sole factor. But cash bail does serve a purpose. If I post $1,000 and know that if I don't come to court, I lose my $1,000, I may have a pretty good incentive to come to court. Maybe I don't. Maybe it's not my money, maybe I don't care. Again, it's each individual person. But when used properly, it can be a very effective tool to ensure someone comes to court and to protect the public. But taking that away from the courts, taking the ability to hold people based on basically an arbitrary criteria, and a very difficult one at that, does not help public safety. So again, I don't express an opinion just on cash bail, as you can argue that either way, and I can see both sides. But I will say this, my hope was that they would start over with the Safety Act, pass it the proper way, sit down with all the stakeholders, come up with a reasonable, logical solution. This has been done in other states. It can be done successfully. It's not the end of the world that we get rid of cash bail, if that's what they want to do. But it has to be done not at 3 o'clock in the morning, not on the last day, not without the input of all the stakeholders, because we all have questions. And we all have uncertainty. Law enforcement should not operate in uncertainty. Prosecutors and public defenders and private attorneys should not operate in uncertainty. Judges should not have to operate in uncertainty. And you as residents should not have to be uncertain of what the law actually is going to be. And if everybody agrees this is an issue, that we're not 100% sure what we're doing, maybe we should fix it before it goes into play. So with that, I'm going to turn it back over to Debbie. I know there probably is maybe one question or two, tops. We're happy to answer the best we can. So thank you.